Okay, welcome back. So lots of you have been asking about California rent increases, especially how it all works with month-to-month leases. You send over a whole bunch of sources.
Yeah, quite a stack. We've got briefing docs, FAQs, stuff from the CA Department of Justice, steadily, Legal Aid Society of San Diego,
The Tenant Protection Act itself, even a Reddit thread and a rent calculator. So quite a mix.
Definitely.
So our mission here is pretty straightforward. We want to pull out the really key information, the need-to-know stuff, so you can get a quick handle on your rights as a tenant and, what landlords have to do when raising rent on these month-to-month deals in California.
Exactly.
Yeah.
Let's dive in. Probably best to start with the big one, the statewide rent cap. That's AB 1482, the Tenant Protection Act.
Right. That's kind of the foundation for all this. It sets a limit, basically.
It does. For most residential tenants, it limits how much the rent can go up each year.
And the main rule, the number everyone needs to remember is, 5% plus inflation or 10%?
It's 5% plus the local consumer price index, the CPI, or 10% total, and this is important, whichever amount is lower.
Whichever is lower. Okay, always the lower number. Good point.
Crucial point. And this generally applies to rentals that are at least 15 years old.
15 years, okay.
Just to make that CPI thing a bit more real, for increases happening between August 1st, 2024 and July 31st, 2025. Let's see, San Diego CPI is 8.6%.
Okay, so 5% plus 8.6% is 13.6%. But wait, the cap is 10% max.
Exactly. So in San Diego, the cap is 10% because that's lower than 13.6%. See how that works?
Got it. So even if inflation is high, there's that absolute 10% ceiling.
Precisely. And just for context, El Orange County is 8.9% CPI. Riverside San Bernardino is 9.3%. So in those areas, too, the 10% cap would likely apply for that period.
And CPI, just quickly, that's basically the cost of living measurement.
Yeah, it tracks the average price changes for stuff consumers buy, goods and services.
Yeah.
It's a benchmark for inflation, basically.
Okay. But like most laws, I assume there are exceptions, times when this cap doesn't apply.
Oh, definitely. There are several key exemptions. For starters, newer buildings, anything built within the last 15 years.
And that's a rolling window, right? Not just built since a fixed date.
Correct, a rolling 15-year window. And the idea behind these exemptions is often, balancing tenant protection with encouraging new construction or protecting smaller landlords.
What else?
Certain single-family homes and condos are also exempt, but only if they're owned by like an individual person or maybe a family trust, not a corporation, not a REIT, not an LLC with corporate members.
So the ownership structure really matters, mom and pop landlords versus bigger companies.
Exactly.
Mm-hmm.
And even then, for that exemption to count, the landlord must have given the tenant written notice saying the property is exempt.
That written notice requirement again. That popped up in the Reddit thread too. People need to look for that specifically.
Absolutely non-negotiable. Can't just assume it's exempt because it's a house. You need that paper.
Okay. Any other major exemptions?
Yeah. Owner-occupied duplexes, so the owner lives in one unit. Also, affordable housing units are typically exempt from this specific cap because they have their own rules.
And crucially, local laws.
Yes,
Yeah.
Super important. Many cities and counties, think LA, San Francisco, San Jose, Oakland, Berkeley,
Mm-hmm.
they have their own rent control ordinances. These could be stricter than the state law, maybe cover buildings the state law exempts. So you absolutely have to check your local city or county rules too.
Always check local. Got it. Okay, so let's say the state cap does apply. Landlord wants to raise the rent. What about the notice they have to give?
Right, notice. It has to be a formal written notice. The Department of Justice is crystal clear. A phone call, a text, an email, nope. None of those cut it legally.
Needs to be actual written notice. Okay, and how much warning do you get? Does it depend on the increase?
It does. If the rent increase is 10% or less, you need at least 30 days advance written notice.
40 days for 10% or less.
Mm-hmm. But if the increase is more than 10%, the notice period jumps up. According to the DOJ, it's at least 90 days written notice.
90 days? Wow, okay. I thought I saw 60 days mentioned somewhere too.
Yeah, some sources do mention 60 days, which can be confusing. But given the Department of Justice is, a key legal authority here, their guidance says 90 days. So it's usually safest to rely on that official source, especially when there's a discrepancy.
Good advice. Lean on the DOJ guidance. And just to be super clear, these notice rules, 30 days, 90 days, written only they apply, even if I'm just month to month.
Absolutely. Doesn't matter that it's month to month. Those notice requirements are solid.
Okay, that's really important for people on those agreements. Now, frequency, can they just keep raising it every few months?
No, there's a limit there too. Generally, A landlord can't increase rent more than twice in any 12-month period.
Twice a year max.
Right. And even if they do it twice, the total combined amount of those two increases still can't go over that annual rent cap, the 5% plus CPI or 10% lower limit we discussed.
Okay, so the total yearly increase is still capped, even if it's split into two smaller hikes. All right, let's imagine a tenant gets a notice and they think, hang on, this doesn't seem right. Maybe the percentage is too high, maybe they didn't get enough notice. What's the first step?
First step, always communicate with the landlord. And do it in writing.
In writing, paper trail.
Always. Explain clearly why you think the increase is unlawful. Maybe breaks the cap, maybe the notice was too short, and ask them formally to cancel it. And keep copies of everything, emails, letters, everything.
Okay, standard advice, but crucial. What if the landlord ignores you or just says, nope, pay up?
Well, if you can't resolve it directly, you've got other options. You can file a complaint with your local housing authority or rent board, if your area has one.
Check local resources again.
And really, in this kind of situation, the strong recommendation from pretty much all the sources is to get legal advice.
Talk to an expert.
Yeah, talk to a tenant rights attorney. They can look at your specific lease, the notice, the local laws, and tell you exactly what your options are. That might include, potentially, refusing to pay the unlawful part of the increase, but you really shouldn't do that without talking to a lawyer first.
Right, don't just withhold rent without legal counsel.
Definitely not. And there are resources out there. Legal Aid Society of San Diego was mentioned. Also, the Martinez Law Center in Santa Ana, they specifically focus on tenant rights, things like unlawful detainer. Their website is martinezlawcenter.com. They cover Orange County, Riverside, LA.
Good to know there are specialists. And you mentioned a YouTube video, too.
Yeah, there's one titled Month-to-Month Rent Increase California that might offer some helpful visual context for folks.
Okay. Now, another term that came up was habitability. How does the condition of the apartment tie into rent increases?
Okay, habitability. This is fundamental. It's the landlord's legal duty to keep the property safe, healthy, livable. Think working plumbing, heating, no major structural hazards, that kind of thing.
Basic living standards.
Exactly. And the connection to rent increases is this. If your landlord is trying to jack up the rent, but meanwhile the place has serious problems they're ignoring, like a leaky roof they won't fix, or no hot water, you might be able to challenge that rent increase.
How so?
Well, the argument is that the increased rent doesn't match the actual, maybe substandard condition of the property. Raising rent while neglecting essential maintenance could be seen as, not acting in good faith. It gives you grounds to push back.
So you can say, hey, fix the serious issues before you ask for more money.
Essentially, yes. The rent should reflect the value and condition, and part of that value is basic habitability.
Got it. Okay, shifting slightly. Eviction. How does eviction risk play into rent disputes?
This ties back into the Tenant Protection Act, too. Once you've been living somewhere for 12 months, your landlord generally needs a specific, legally valid reason, what's called just cause, to evict you.
After a year, they need a good reason.
Right. And these reasons fall into two buckets. At fault, which is stuff like you not paying rent or breaking the lease.
Things the tenant did wrong.
Correct. And then no fault, which includes things like the owner wanting to move in themselves or taking the property off the rental market.
Okay, two types of reasons.
But the absolute key thing here regarding rent increases is a landlord cannot evict you or even threaten to evict you just because you challenged a rent increase you thought was illegal or because you exercised some other right, like asking for repairs. That's illegal retaliation.
Makes sense. You shouldn't be punished for standing up for your rights.
Exactly. And even if it is a no-fault eviction situation, maybe happening after a rent dispute, the landlord still has to follow very strict procedures. And often, they have to pay relocation assistance.
Relocation money, how much?
It's often equivalent to 1 month's rent, though the specifics can vary, sometimes based on local ordinances, too.
Local rules again. Seems like a recurring theme.
It really is. State law sets a baseline, but your city or county might offer even more tenant protection. Always check locally.
Okay, let's circle back hard to the main topic. Month-to-month leases. Any specific quirks just for them besides what we've covered?
The main takeaway is really that month-to-month leases don't get you out of these rules. They are fully covered by the state rent caps, the state notice requirements, and any stricter local rules.
So that idea that maybe, because it's month-to-month, the landlord has more freedom to just raise rent whenever by however much, that's wrong.
That's generally wrong, yes. We did see one source mention something like a landlord could raise rent by any amount with proper notice on a month-to-month, but that statement really clashes with the statewide rent cap law, AB 1482, which most other sources confirm applies. So don't rely on that idea. The caps and notice rules are the key things.
Good clarification. What about the owner move-in thing? Can they end a month-to-month for that?
Yes, owner move-in, or for a close family member, is one of those no fault just causes for eviction we mentioned. But again, there are strict rules. They have to intend to live there for a certain period, follow notice procedures, potentially offer you a similar unit if they own one, and usually pay that relocation assistance.
So it's not just a simple, I want my place back situation. There are hoops to jump through.
Definitely legal hoops, yes.
Yeah.
Designed to provide some protection for the tenant, even in a no-fault situation.
Okay. So wrapping up for tenants on month-to-month leases, what are the practical, proactive steps they should take? What's the checklist?
Right. Action items. First,
Yeah.
know your lease agreement. Read it. Understand it.
Know the contract.
Second, get familiar with the state and your local rent laws. Knowledge is power here.
Do your homework.
Third, document everything. Keep meticulous records of any problems with the unit habitability issues and log all communication with your landlord. Dates, times, what was said or written. Emails, texts, letters.
Paper trail, paper trail, paper trail.
Can't stress it enough. Fourth, if you're facing an increase and thinking about negotiating, research local market rents. What are similar places nearby going for? Data helps.
Come prepared if you want to negotiate.
Fifth, try to build an emergency fund if you can. Having some savings gives you options and reduces stress if a rent hike does happen.
Financial buffer. Sensible.
And finally, if you want more predictability than month-to-month offers, consider asking your landlord about signing a longer lease, maybe 6 months or a year. Might give you more stability on the rent.
Explore a longer lease for stability. Okay, that's a great list of actionable steps.
Yeah, hopefully helpful.
So let's try and boil this whole deep dive down. What's the main headline for someone listening?
I'd say the headline is, California law, including the Tenant Protection Act, gives you real protections against excessive rent increases, even if you're on a month-to-month lease. You're not just left hanging.
Okay, so don't assume month-to-month means no rights.
Definitely not. Know your rights. Regarding the rent cap, that 5% plus CPI or 10% lower limit. Know the notice rules, 30 days or 90 days, always written. Check your local ordinances for potentially even stronger protections.
And be proactive.
Absolutely. Communicate in writing, document everything. Don't be afraid to seek clarification or help if something seems wrong.
Great summary. So maybe a final thought to leave people with.
Well, we've talked a lot about the rules, the landlord's obligations, the tenant's rights. It often comes down to this balance, right?
Yeah.
The landlord needs to maintain their property, cover costs, maybe make a profit. The tenant needs stable, affordable housing.
That tension is always there.
It is. So maybe the thought is, beyond just knowing the strict legal rules, what are the best ways for tenants and landlords to actually communicate effectively and maybe find fair solutions when rent increases come up? How can that conversation happen more openly?
Interesting angle. Moving beyond just the legal minimums to better communication.
Yeah, something to think about. Maybe looking into local tenant groups or mediation resources could offer some insights there too.
Food for thought. Thanks for breaking all that down.
You're welcome. Glad we can cover it.
Call now 714-442-9741. Thank you.